Welcome to the Explainer. So, have you ever wondered what actually stops the government from just changing the rules of the game completely overnight? Well, today we're cracking open a case that reads less like a dry legal document and more like a high-stakes legal thriller. We're looking at the 2003 South African Constitutional Court judgment of the Minister of Home Affairs versus Eisenberg and Associates. This is a fascinating story about a ticking clock, a brand new legal framework, and a fundamental clash over how laws are actually made in a modern democracy. Can a government minister rewrite the rules without asking the public? This right here is the core conflict we're exploring today. On one side, we've got the absolutely vital democratic principle of transparency and public consultation. But on the other side, the urgent, practical reality of a government needing to implement complex systems without any delay. So, where exactly do we draw the line between unchecked executive power and necessary government efficiency? Okay, let's dive right into this. We're going to use this docket to unpack this highly complex showdown step by step. First, the immigration showdown. 2, the two rulebooks. 3, the High Court ruling. 4, the Supreme Court reversal. And finally, number 5, the final verdict. Part 1, the immigration showdown, setting the stage for a constitutional clash. Let's travel back to early 2003. South Africa is in the middle of overhauling its outdated immigration system under the new Immigration Act of 2002. Enter our two main actors. On one hand, we have Eisenberg and Associates, a specialized immigration law firm fighting fiercely for the public's right to be consulted. And on the other, we have a minister rushing to implement this brand new nationwide system on a super strict, immovable deadline. The friction really kicks off when the minister drops sweeping new regulations practically overnight. Now, what's really interesting about this timeline is just how incredibly tight it is. Look at this. The deputy president had issued a proclamation bringing the new act into force in stages. On February 20th, the regulation-making powers in Section 7 and 52 go live. The very next day, February 21st, the minister publishes the new regulations. Just 5 days later, the Oversight Board is legally established, and on March 12th, the entire act goes live. I mean, the minister basically crammed for a final exam overnight. He suspiciously published these massive regulations just 1 day after receiving the power and mere days before the Oversight Board even existed. Part 2, the two rulebooks, decoding the Immigration Act 13 of 2002. This is where we need to put on our detective hats, because this entire case hinges on two conflicting sections in the new law. Let's compare them side by side. Section 7 represents our democratic idealism. It requires the minister to publish his intent, allow a minimum of 21 days for public comment, and officially consult the Immigration Advisory Board. It's a rigorous, consultative process. But then we have Section 52, which acts as this pragmatic, transitional emergency brake. It clearly states, until the board is duly constituted and operational, any regulation required shall be prescribed. So Eisenberg and Associates argued Section 7's transparency rules should apply everywhere, no matter what. The minister argued Section 52 gave him a temporary bypass to just get the system running. So, who was right? Well, the answer is kind of hiding in the fine print, specifically in the transitional definitions found in Section 51. The law explicitly stated that during this brief transitional phase, the word prescribed simply means adopted by the minister and published in the Government Gazette. That's literally it. No 21-day waiting period, no mandatory public comments. By relying on this legal loophole, the minister legally sidestepped all those heavy consultation requirements of Section 7. Part 3, the High Court ruling, a victory for public consultation. Furious at being completely shut out of the process, Eisenberg and Associates launched an urgent application in the Cape High Court on February 25th. And you know what? The High Court agreed entirely with them, and they issued a remarkably severe warning. They explicitly stated that without a process of public comment, members of the public might be confronted with arbitrary, capricious, or even oppressive regulations as a done deal. The lower court viewed the minister's actions not as a pragmatic necessity, but as a dangerous, unfettered grab for power that just completely bypassed the basic values of democratic transparency. And so, on March 11, 2003, the High Court dropped an absolute bombshell. They invalidated the minister's regulations entirely, insisting that Section 7's public comment procedures absolutely had to apply even during the transition. But remember our timeline? This ruling came down exactly 1 day before the entire Immigration Act was supposed to go live. The High Court refused to suspend their order of invalidation, which effectively brought the country's entire immigration system right to the brink of chaos overnight. Part 4, the Supreme Court reversal. Chief Justice Chaskelson steps in. With the system facing a total meltdown, the minister appealed to the Constitutional Court, and Chief Justice Chaskalson steps in to unravel this crisis with some incredibly airtight logic. Let's walk through it. Step 1. The Act absolutely needed implementing regulations to go live on March 12th. Step 2. The Oversight Board didn't legally exist yet. Step 3. By its very definition, Section 7 strictly requires consultation with that board. Step 4. Therefore, it is physically impossible to use Section 7, and the transitional powers of Section 52 must apply. The Constitutional Court made a highly compelling, pragmatic argument that the minister wasn't going rogue, he was simply doing the only thing mathematically possible under the statute. But Chaskalson was also really quick to contrast the High Court's fears with reality. He noted that the minister's powers are not unfettered and are always subject to constitutional control. The Constitutional Court reassured everyone that, hey, if the regulations were actually oppressive, arbitrary, or violated human rights, they could absolutely still be struck down. But that wasn't the case here. Nobody was arguing the rules themselves were unconstitutional. They were literally just arguing about the timeline and the paperwork. So the crucial point here is understanding the real-world stakes. The High Court basically assumed that if they struck down the new rules, the old Aliens Control Act regulations would just naturally step in and fill the gap. But Chaskalson pointed out a fatal misunderstanding there. The old regulations were completely incompatible with the new system, which relied on entirely new types of special permits. Without the minister's fast-tracked regulations, immigration control wouldn't have just been messy, it would have completely collapsed on March 12th. Part 5. The final verdict. Paja and the balance of power. Now, even though they lost on the Immigration Act arguments, Eisenberg tried one last-ditch legal maneuver. Paja. That's the Promotion of Administrative Justice Act, and it regulates what is formally called administrative action. What does that actually mean? Well, in plain English, it's any decision made by a government official that negatively impacts your rights. Paja usually guarantees the public's right to procedurally fair notices and mandatory comment periods for any such action. Eisenberg argued that even if the Immigration Act didn't specifically require public comment, Paja absolutely did. And this brilliantly illustrates how the law actually accounts for reality. The Constitutional Court noted that even if we assume making these regulations counts as an administrative action under Paja, there's an escape hatch built right in. Paja Section 4.4 explicitly allows a departure from public comment procedures if it's reasonable and justifiable in the circumstances. Given that looming March 12 deadline and the very real threat of a complete collapse of border control, the minister's solo sprint wasn't just logical, it was completely legal and justified under Paja. Ultimately, the Constitutional Court upheld the minister's appeal, but they definitely didn't stop there. They delivered a really sharp rebuke to the lower high court. By effectively forcing the old, repealed regime to stay in power, the lower court had crossed a major line. The Supreme Court called it an unjustifiable interference with the will of Parliament. It was a powerful reminder of the separation of powers. Judges interpret the law, right? But they cannot casually suspend valid legislation enacted by lawmakers just because the transition looks a little messy. Which leaves us with this final thought to ponder. We've seen how the text of the law and the ticking clock of reality collided in this massive case. But zooming out from the legal technicalities for a second, it forces us to ask a much broader question. When exactly does the urgent need for government action and efficiency actually outweigh your democratic right to be heard? It's a delicate, dangerous balance, and it's a tension that sits at the very heart of how we govern ourselves. Thanks so much for exploring this legal thriller with me on The Explainer.